The first one is Sean M. Duff, versus State of Florida. Are you ready to proceed?
Yes, I am.
You wish to reserve any time?
Your Honor, at this time, if I may reserve 5 minutes for rebuttal.
You got it. You may begin, sir.
May it please the Court. My name is Adam Sudbury, and I'm here appearing on behalf of Mr. Duff, the appellant in this case. We've presented two alternative arguments in this case of why a subsequent conviction for driving while license revoked as a habitual traffic offender violates double jeopardy principles here in Florida after a previous conviction for driving while license suspended. Your Honors, I would first like to state that it's been well recognized the Florida Constitution extends additional protections on top of the United States Constitution. The Florida Supreme Court has recognized that repeatedly, and in this case, it's our position that the Florida Constitution does in fact provide those additional protections and results in the appellant's position being the one that should prevail here. This case involves the fundamental evil of a first prosecution resulting in a conviction, followed by a second subsequent prosecution.
They call that double jeopardy.
Yes, Your Honor. And however, the case law on subsequent prosecutions is somewhat unclear. There was a United States Supreme Court opinion in 1990 called Brady versus Corbin, which established the principle that a government cannot use conduct in a second prosecution that it had already proved in the first prosecution. That was later overruled by the United States Supreme Court, but in the interim, it was adopted by this court in the Williams case. And so the ultimate question on that is whether or not the Florida Constitution provides that same protection. And here, the state has cited the case of, it is the Gaber case out of the Florida Supreme Court, which does talk about the quote-unquote same conduct test. Now, the difference in the Gaber case on the basis of the same conduct test is that in Gaber, it does talk about where the state is trying to use the same conduct in different statutory crimes. However, in Gaber, there was only one prosecution. They were trying to do that during the same proceeding, and it was held later that was okay because the two crimes involved were separate under the Blockberger test. So here, where we have successive prosecutions, where the defendant has not only pled to one and been sentenced, but he pled pro se without the benefit of counsel, the state has then come back and attempted to seek a second conviction on a crime, not only that it's similar, but it involves the same basic fundamental.
Counsel, your argument is that it violates the degree variance test?
Yes, Your Honor, it does.
Let me ask you another question. Would you concede that the county court probably didn't have jurisdiction on this case?
Your Honor, I would concede that, based on the exclusivity provision.
Does that have anything to do with your, I mean, how does that play into your argument and the outcome of this case, if we assume that the county court really had no jurisdiction in the first place?
Well, if the county court didn't have jurisdiction, I don't think it would necessarily affect this particular proceeding at all. And the reason why that would be so is because he already was sentenced and actually spent the 30 days in jail.
So he spent 30 days in jail, even if you concede they didn't have jurisdiction. Okay.
correct, Your Honor. And it's not the jurisdiction of the court that defines whether someone's been placed in jeopardy. It's what actually happens. If there's a jury trial and a jury is sworn and someone goes through a trial, even if the court didn't have jurisdiction, as I believe that is probably the basis for the 4th District's opinion in the Cook case. That person is still faced a jury, has still been charged with a crime, has still gone forward and had to deal with the possible consequences. So it's not really the jurisdiction of the court that defines whether someone has been placed in jeopardy. And here it's even more compelling because he actually served 30 days in jail based on the same set of facts that they're now trying to convict him of a felony with, and have convicted him of a felony. And so if it were true that whether or not someone's been placed in jeopardy is based on whether or not the original court had jurisdiction, then...
Let me ask you about the jurisdictional question. I thought in the county court he pled to a misdemeanor DWLS.
That's correct, Your Honor.
And you know, certainly the state attorney is free to reduce a felony. The state attorney's office was there, and they said, you know, we'll offer him a plea to DWLS in 30 days. And what's the jurisdictional problem there? I agree that they don't have any jurisdiction over the DWLS as an HO, but the crime that you contend that he was sentenced on, where's the jurisdictional problem?
There is no jurisdictional problem with respect to driving while license suspended.
Well, but if I understand your argument is that DWLS, misdemeanor DWLS, punishes the same core misconduct as driving while license canceled, suspended, or revoked as an HO. That's your double jeopardy argument.
Yes, Your Honor.
So why are we worried? I mean, I think we all agree that the county court had jurisdiction over the misdemeanor DWLS charge.
That's true, Your Honor.
Why are you conceding away? I'm trying to have a problem here because I don't buy the idea that if the prosecution in the county court was completely void and there was no jurisdiction, that jeopardy could ever attach to a void prosecution. But I'm trying to understand why you're falling on your sword on that one when it doesn't seem like your position is well taken.
Well, Your Honor,
and I don't want to make your argument for you, but they got jurisdiction on the misdemeanor DWLS charge. On
the misdemeanor charge, that's true, Your Honor. A county court absolutely has jurisdiction over that particular charge. I think the initial problem was that in the statute they're mutually exclusive. But I would definitely agree that if the state does choose to amend the charge, which in this case, if you consider both of the charges being represented by the state and then they allow the individual to plead to the misdemeanor, that can operate in a kind of a way of estoppel from them going forward on the greater charge.
I think in this case, I mean, wasn't it the state attorney who said, you know, if he pleads to DWLS, we'll recommend 30 days?
That's correct, Your Honor. He did.
It wasn't just a matter of the state attorney being asleep at the table while all this was going on.
Yes, Your Honor. And he, in fact, did make that offer.
So isn't the real crux of the issue here whether or not those two offenses, the felony of which he's been convicted and the misdemeanor of which he's convicted, punish the same core misconduct? I mean, isn't that really the question that we have to resolve?
It is. That is the question. I think that this court in particular has addressed that question in the past. In the Rodell case at 773 Southern 2nd 1280, Rodell does specifically say that driving while license revoked, it may have been the felony driving while license suspended or driving while license revoked. They all punish the same core offense. And that same core offense is driving without a valid license. And so they are degree variants of each other in the sense that they share that one common denominator. And all of the cases that address this point, all of the cases that address this point do in fact have that one common aspect, that if they share the same lesser included, they are necessarily degree variants of one another. Thank you, Your Honors.
May it please the Court, my name is Chris Davenport and I represent the state of Florida. First of all, let me clear up a couple of things that this case is not about. The Florida Constitution does not provide greater protection under the Double Jeopardy Clause than the Fifth Amendment to the United States Constitution.
You would agree that double jeopardy still applies in Florida?
Of course, but it's never been interpreted in a more broad sense than the United States Supreme Court has interpreted the Fifth Amendment.
Do you agree that the real question here is whether or not the misdemeanor of which he was convicted and the felony of which he was convicted punish the same core misconduct?
I believe that the question here is whether the misdemeanor and the felony are the same offense. Because if they're the same offense, they can't be.
They're clearly not the same offense. I mean, I think we all agree that they're not the same. I don't think he's arguing that they're the same offense. I think his argument is that they punish the same core misconduct or degree variance of it. I'm more impressed of the two arguments. I'm more impressed with the same core misconduct.
Right.
I mean, to me, that seems like the issue we've got to resolve. But if you want to go in a different direction, feel free.
I think that is definitely his best issue. The same conduct test clearly isn't the law in Florida. Dixon overruled Grady and the Supreme Court.
I agree with all that stuff.
So all of those things.
I'm focused on
right.
trying to understand. Help me understand why, if I understand what this fellow pled, he pleads to misdemeanor DWLS and gets sentenced. And we all agree it all arose out of the same incident. I mean, we're, no problem there.
Right.
So he pleads to misdemeanor DWLS, and then he's prosecuted for DWLS as an HO in felony court. So what core misconduct? Now, there are a lot of different reasons why your license may get suspended, canceled, or revoked, right? We all agree that there are a myriad of reasons, from being a terrible driver to things as innocuous as not paying your child support, which has nothing to do with your ability to drive, to being convicted of a misdemeanor drug offense, which may or may not impair your ability. So there's a million reasons why your license might get revoked or canceled or suspended, but isn't the misconduct that we're trying to get at here is, if you drive, you've got to have a valid driver's license?
I think in the broadest sense of the word, yes, they are the same. In a really broad view of the statute, they're the same conduct. They're both sections punish people who drive without a license.
And isn't really the only difference is that we say if you've had your license revoked as an HO, then whatever conduct got you to that point was either more repetitive or more egregious, generally more repetitive, than the guy who just simply forgot to pay his traffic ticket and got D6.
I think there's a significant difference between having your license revoked under the standard misdemeanor charge, where it is stuff like if you drop out of school, your license gets taken away. A lot of things that have nothing to do with driving. Versus the habitual traffic offender, those are people who've committed serious traffic offenses, DUI, leaving the scene of an accident. I mean, it's not little weird stuff like drug offenses or things like that. These are seriously bad drivers.
Well, but isn't that why the state has the option? I mean, I guess the problem that I'm having here is, should the state have two shots at the guy, which is your argument, or should you have to pick, well, we're going to, give the guy a break and prosecute as a misdemeanor, or give him the full Monty and take him to felony court? I'm just having a hard time understanding why simply that the reason that your license was suspended changes what I view to be the core misconduct, which is if you get behind the wheel, you got to have a valid driver's license.
I think
If you
that's-
don't have one, then if you don't have one for an innocuous reason, it can be a misdemeanor, and if you don't have one for a really bad reason, it can be a felony.
the reason that you can prosecute them for both, first of all, you can have your license suspended for both reasons. 2 of them as a habitual traffic offender, and 7 for other things like failure to appear and things like that. So this is an example of a guy who has violated both sections. And since they do address different core conduct, the first section, we want people to have a valid license.
Counsel, if that's correct, and it is, then why didn't the state of Florida take him into felony court and prosecute him there?
They did.
Yeah, but only after they've taken him into county court. Why is it waste time with county court? Why don't you just go into, if he's that bad, start off with felony court, and then you don't have this problem?
Well, when he entered his plea, the information for the felony had already been filed. He went in there, and one could say that this reeks of sandbagging a little bit. He went in there and entered a plea to his misdemeanor real quick.
You don't contend that this pro se defendant had more information available to him than the great state of Florida, who was prosecuting him with the same state attorney's office in 2 different divisions of the court.
I think
You don't think that the left hand didn't know what the right hand was doing in the state attorney's office, do you?
Of course not.
I'm glad we've put that to rest.
Ideally, this would have been consolidated into felony court. But the other thing is, the defendant knew exactly what was happening, too. He knew he was a habitual traffic offender. The information had already been filed against him. He doesn't exactly come in with ignorant, clean hands either. Ideally, this would have been consolidated.
But this isn't a
into
question of
felony.
equity. This is a question of constitutional law.
Yes.
So while I appreciate your equitable argument, I'm having a hard time understanding how whether his hands are clean or dirty play a role here.
Let me go back to the core conduct, because I think that is the key issue in this case. I think you're absolutely right about that. When you look at the way the statute is, and the whole point of the core conduct test and Blockberger and all those tests is decide if the legislature intended for these to be separate offenses for double jeopardy purposes. When you read how this statute is written, it specifically says in Section 2, it doesn't apply to habitual traffic offenders. And then in Section 5, it does. They're clearly set out as mutually exclusive offenses. This guy happened to fall under both. According to the traffic ticket, his license has been suspended both ways. He doesn't pay attention to the little things that cause you to get the license suspended in a normal manner. Plus, he commits all these heinous offenses like DUI and things like that get your license suspended as a habitual traffic offender. Those are 2 different categories of evils. They're both drivers, and we both want drivers to not be on the road who do these things. But one of them is more of a regulatory, we're going to slap you and try to get you to comply, versus one of them is you're a seriously bad driver, and it's a felony if you're out there on the road, and we don't have to prove knowledge, and it's a much more serious offense. Yeah, they both punish somebody who's driving without a license, but when you look at the misdemeanor offense, it's people who do it repeatedly, they get slapped harder each time, and it's for little things that often have nothing to do with your ability to drive.
Of course, the irony here is you got slapped harder in county court for the misdemeanor than it is in felony court. But I realize that that's not terribly germane to the discussion.
Right.
But it is
It's a
ironic.
felony conviction in felony court.
Counsel, wouldn't you concede, though, that what the county court judge should have done was to just transfer the as a felony, because he had, even though he was pleading guilty to a misdemeanor, it was obvious that he was, and it seems to me that if that had happened, you wouldn't need to be here today, would you?
Right. We wouldn't. Like I said, ideally, it would have been sent to felony court and consolidated. But if that had happened, I think he could have been convicted of both crimes. And under Dixon, it doesn't matter that they were successive prosecutions. The analysis is the same. Can you be convicted of both crimes? And the way the statute is phrased, they're mutually exclusive. They're clearly 2 different crimes. I don't think we even need to get to the core conduct test, because the legislative intent is that these are separate crimes. It's very clear in the statute when you make them mutually exclusive like this that the legislature intended this to be 2 different crimes. given that, even if you use the core conduct test, broadly, they both punish drivers who don't have a license. But this isn't the same thing as driving without a license and driving with a suspended license, where you have to commit one to do the other. These are two very different categories of people that we're trying to keep off the roads here. One of them is a felony. They're bad drivers. They've done bad driving kind of things. The other ones didn't pay their fines and had their license suspended. And you need to take care of that from a regulatory perspective. You can't have people just flouting the law and driving without a license. And that's why they hit them harder every single time, even though it might have nothing to do with why their license might be suspended for nothing to do with driving. They still have to get it. They still have to follow the law. We want to be able to regulate them. The other category is a very different type of driver. It's much more narrow. It's people who are committing serious traffic offenses. And in that sense, I don't think they regulate the same conduct. And I think the legislature has clearly said that these are two separate offenses, and they can be successfully prosecuted. It's not ideal what happened to this guy, but it's certainly not unconstitutional. If there's a problem and he doesn't qualify under the misdemeanor thing, he should go back and attack his plea to the misdemeanor. If he thinks there's some kind of a jurisdictional problem or he thinks he doesn't fall under that, that's where the problem is. But he clearly falls under this felony, and it didn't violate double jeopardy to successfully prosecute him, because he could have been convicted of both in felony court. So we would ask this court to affirm.
Thank you.
Thank you.
Your Honor, if I may briefly readdress the jurisdiction issue that I've had some time to think about. I think the issue that in there is that the statutes do make the two offenses mutually exclusive. However, that is not an issue of jurisdiction. That may be a possible defense in the misdemeanor case, and that's a factual issue as to what the driving record says ultimately, which can be stipulated or not stipulated either way. In this case, it was stipulated in the misdemeanor court that his license was suspended. And so in that case, it wouldn't be a jurisdictional question, but a possible defense later, as in the Cook case, where in the first prosecution it was raised at judgment of acquittal. And when we get to the issue of the same core misconduct, the test is not whether or not the statutes are separate. And with all due respect to the state, the degree variance test is an additional protection. There is no such thing as the degree variance test in the federal system. And so that's an additional protection that Florida has afforded criminal defendants. And the question is not whether they're merely separate or they punish different types of people without licenses. The question is whether they punish the same basic conduct. And if the two statutes share a common lesser included offense, and in both of these cases there is a category 1 lesser included that is anyone may ask for, and that's driving without a valid license. And if that's true, and they both share that common lesser included offense, then necessarily they punish the same basic criminal conduct. And so in this case, where we have, in fact, two statutes, two pleas, and two punishments for crimes that share a common lesser included offense, the degree variance principle of Florida is violated. The only question there, however, is that does not address the successive prosecution issue, which it is our position that that is the greater evil in this case, that the state has to bring their charges all at the same time. The state cannot selectively prosecute on some charges and then later they don't like the outcome. My client only got a misdemeanor conviction. They don't like it. If it's permissible for them to prosecute 2 or more times, then they can just go back. They don't like what the judge sentenced them to. They can go back and come after them with something else that they didn't originally charge. And that is the principle that that's what this case really is about, is the fact that they have come back twice and tried to convict him twice in temporally separate occasions.
Thank you.
Thank you, Your Honors.
Thank you both.